Obviously, you would have 15 minutes and you could reserve up to 5.
I appreciate that, Your Honor. Just for the record, Attorney Greg Price for Mr. White, if I could reserve 4 minutes, I'd appreciate that. This issue before the court today, and I know whenever we come in with criminal matters, we always have a manifest weighted evidence argument. That's not before the court today, specifically for one reason, and I think it goes directly to our first two assignments. The first two assignments are, one, the trial court failed to properly take judicial notice of part of Ohio's landlord-tenants law. The second part of that challenge, Your Honor, which is our second assignment, is that trial counsel was ineffective in their approach to handling that defense and taking that to the court. There are very few times, Your Honors, where a person can take the stand and admit to something and they not be found automatically guilty. There's whenever you just have an affirmative defense, you can say, yes, I shot that person. However, here's my justification for doing so, and the law can find you not guilty. This is not an affirmative defense, but this is as close as you can get. What Mr. White's defense was at this trial was, yes, I went to that house. Yes, I tried to take things. But the reason I did so was because I had permission to do so. And if the court looks at the transcript, what you're going to find is Mr. White taking the stand, and he will say that. He will say, absolutely, I was in that house, absolutely. I went to take these things. There was a confrontation with the man that was there. I immediately left. And I bring that up because I want the court to appreciate the tactic that was taken in this case. A lot of times we approach these cases and say, well, defense counsel is going to give them a lot of latitude whenever it comes to strategy because we don't know exactly what that strategy is at all times. In this case, we know exactly what the strategy was. The strategy was, one, we're going to ask for judicial notice of the landlord-tenant laws, which is going to get us to, this woman can give him permission to be in the house. Because once again, Mr. White didn't live in this house. He didn't have anything associated with this house. The only association he had was with the woman that lived there. If the woman that lived there could not give him permission, Mr. White could not bring this defense.
And maybe I'm remembering this case wrong, but isn't this the one with the broken window?
And some of the facts, Your Honor, they were driving down the road, 2 men, 1 woman. Police pulled him over. Mr. White's driving. The woman in the back. They pulled him over for a driving infraction. The police come up and they basically do a run on everybody in the car. They find that she has warrants. Mr. White's defense says, well, at that point, she says, look, I'm going to jail, but I need you to go to my apartment and get my things. But the question then becomes, does she have authority to do that?
Well, even if she did, hypothetically, she did have the authority to tell him to do that, what would give him the right at 2 o'clock in the morning to go into the house?
And I think from my reading of the transcript, they did went from point A to point B, which was the apartment. Now, is this the best approach to get into the house? I agree with you.
Especially when there's somebody home.
There's somebody
I
home.
didn't understand what you said there, I'm sorry. They did point A and point B, but I didn't hear it before that.
So whenever they got pulled over, he was simply cited for a traffic infraction.
In the afternoon.
And then he went over there that night to get the things. Now,
Not
is this
through the front door.
not through the front door, through the window? Is this the best way to do it? Absolutely not. And
Well, it gives the impression that you don't have permission.
and that's also
Especially when there's
part of
somebody
it.
home.
And they didn't know about the person home.
Well, if they knocked, they might have known.
And if they did that, but what they did know is that she lived at the apartment, she wasn't there, and they had no other way to get in the house.
They didn't know they didn't have any other way because they didn't knock on the door.
And it's also 2 in the morning, Your Honor. It's got to bite both.
I guess that would be my point.
And the facts, and the question at this point, and the state brings this up in their brief, you know what, even if this did happen, there's absolutely nothing else that would have changed, because you do have a bad time, and you do have somebody trying to climb into a window. But at the same point, whenever you talk about a person's defense, and you say, look, I'm going to put you on the stand, I want you to admit to these things. And here's my strategy.
How would landlord-tenant law have changed that?
The landlord-tenant law, I think, in reading specifically what they cite to, Your Honor, if I remember 5321.01D, and I think that's about right. And I think D deals with rental agreements themselves, how they can be both written and oral. A lot of the testimony was that there was nothing in writing, nothing written, nothing written. But whenever the state brought that up, that was the testimony they focused on. Did you ever have a written lease? No, we didn't have a written lease. Did you ever have a written lease with this woman? No. But I think what defense counsel is getting at here is that this can be an oral agreement, where she has, on several occasions, the landlord knew that she was living there. On several occasions, the person that was supposed to be, and with my air quotes, I apologize to the record, but the person that was living there knew that she was living there. She was paying rent. She paid rent to the person that was living there, and she paid rent to the landlord. All those things combined under landlord-tenant law will get you to the point that she had permission to allow people on that property.
But, and even if that were the case, stranger to the other person that's living there, the permission to break into the house.
And I think breaking in's gonna be a little bit severe. What,
Okay.
I think the testimony was the window was open, he pushed a fan that was on the other side of that window, was pushed over whenever he came through the window. I think it's severe to say he broke the window and was breaking in that. But-
I probably am overstating it.
But,
But the point is, isn't there a difference? It's one thing to give somebody a key.
correct,
It's another thing to, as Judge Schaefer said, go up and knock on the door and say, you know, that,
Rachel said I could come to your
Yes.
stuff.
yes. Now, there is a distinction, and I'm not gonna argue that, is there a better and best approach to this situation? But what I would argue, Your Honor, is in your situation, you're saying, look, that can't be possible, but that absolutely is possible. I can tell somebody they can be on my property, go get my things, they call me and say, look, you said you had a hidden key, you don't have a hidden key, and I can say, look, my dogs, my cats, they're gonna die if you don't feed them, break a window. Now, is that the best way to do it? And they say, look, I can't do that till after work, it's gonna be dark. I break that window, get in. And once again, I'm not condoning the approach that they took, but what I'm saying is, what they did was legal under the fact that she can give them permission to do that. And I would say yes to that.
and I guess where my concern with that theory would be if she lived alone and just rented an apartment, it's one thing, but she didn't live alone.
And she didn't, and then that once again goes to the question of who do they know lived there? I think part of the transcript, if you read through that, they're gonna say that they were there before and that this person didn't like them. Well, if I knew that this person didn't like them, knew that
Would I break in the middle of the night?
and what I would try to do is kind of go there when I hope that he's not there and maybe hope that nobody's gonna
Or
notice.
have a gun and shoot me?
And to be completely honest, Your Honor, that's all an option. But at the same time, the question becomes, is that a viable sense in the terms of permission? If she has the right to give that permission, and she says, go get my things at all costs, and they've done that, yes. Is it the best option? No, and I would agree with that 100%. But whenever we're looking at this, and we're looking at the trier of fact, and we're looking at this jury, all the evidence they got to hear was a woman take the stand and say, no, I didn't give him permission. But then whenever the defense comes up and says, look, my entire strategy is to now put you on the stand and I'm gonna get judicial notice of the fact that she can give permission. Well, the question going to the jury at that point is, how much do you weigh her statement? Do you believe that she gave permission? Do you believe that the person sitting in jail hoping to get favoritism from the prosecutor might be lying to you? Do you believe that the person who really wants to carry favor with the person who still has all her things, would she want to carry favor with that person? Would you believe Mr. White who said, look, she absolutely told me to do this. I apologize for taking a terrible approach to doing it, but she asked me to do that. And based on the trial attorney's strategy, that completely goes away. There is absolutely no way that you can find that she gave permission because there's no judicial notice, there's no instruction on whether or not she can give permission. The question before the court that we bring up today is, was trial counsel prejudicing Mr. White by telling him to take the stand and admit these things when making no support, no foundation for the claim that he had permission? And that's really the key. Now, is their approach good, is it bad? All those things, that goes to the validity of whether or not they did with permission. But defense counsel made no efforts to show that except for the judicial notice. And Your Honors, for our third argument is the restitution issue. And I know this comes up in front of the court so many times, and I've had it so many times. What the trial court does is they put a sentencing order for get restitution, say it'll be figured out sometime down the road. That happened in this case. The first filing was dismissed because it's not a final appealable order. So what they do is they go back to the trial court. The trial court says, what's probation say? $750. Okay, we're done. In this case, Mr. White objected to that and asked for a hearing. And the trial court said, no, probation gave us $750. That sounds about right. And I heard the testimony. The testimony during trial is not a restitution. It does not specifically go to the amount lost, the amount returned, insurance coverage, anything like that. In fact, I think at a trial, all that testimony would be irrelevant and probably be objected to and just not be any part of the trial itself. So what we're asking for is whenever someone asks and objects to that number, that there is a hearing and that Mr. White be present for that hearing. And, Your Honor, aside from my 4 minutes, I would see the rest of my time to the state for this. Thank you.
May it please the court, Assistant Prosecutor Rachel Richardson on behalf of the state. Your Honors, I believe that the reading of the record will demonstrate that the defendant in this case had no basis to enter the home. Even if we did take judicial notice that there was a landlord-tenant relationship, it's irregardless in this case because the defendant entered in the middle of the night through a broken window, a window that presumably was broken earlier in the night when the defendant had entered the home and stolen items previously with the perceived tenant in this case. Entering through this in the middle of the night, also knocking over a table. There's also no evidence that when approached by the gentleman who owns the home, that they know owns the home, that they made any reference to, we're just here to get so-and-so's things. There's no reference to any of her items actually being taken from the house, as the restitution hearing and all the information that's been presented. The information shows the only items taken were the items of the defendants, or of the victims. The items of the presumed tenant, Ms. Kearns, were not on any of the co-defendant or the defendant. Excuse me. There's a briefcase filled with items. The items all were men's items. They were not women's items. The items belonged to Douglas. He identified them first. He knew the people that had entered into his home. The testimony of the tenant states that she did not have permission. She did not grant permission. She did not consider herself a tenant. The landlord says that she's not a tenant. The tenant of the property, Mr. Douglas, says she's not a tenant. There's no evidence saying tenant except for one request made by defense counsel to have judicial notice taken of the landlord-tenant statute. Frankly, the court made a good decision here by not taking judicial notice of landlord-tenant law, revised code section. Well, the revised code section here mostly pertains to cases where we take someone to court on an eviction matter or some type of a civil matter. Rarely is this used in such a burglary case because the facts would prove whether or not someone broke into a property with or without permission.
Sure, but it's my understanding that Kearns testified that she did not give him permission to enter the park. So that was something that she,
Exactly. Yes,
so under oath, she swore she didn't give him permission.
Exactly.
But then he's claiming that she did.
correct. And he had the opportunity to present that information after she presented her information. Frankly, defense counsel can't make the defendant testify. The defendant is under oath to testify truthfully, just as Ms. Kearns was. It's not defense counsel's fault that the defendant's argument was that he had permission. Really, sometimes there's just a bad situation of facts and they happen to fit into a crime. That's really what we're talking about here, is the defendant made a bad decision. He entered into a property in the middle of the night through a broken window that he presumably broke earlier in the day and tried to steal more items because he had a presumed drug addiction and drug problem which he could sell the items. Are there any questions about this case?
Apparently not. All right.
We'll defer to the brief. Thank you, Your Honor.
And Your Honors, I think I've hashed out everything I'd like to, but there is one more issue I'd like to point out. If the court goes to 5321, I would agree with the state that that section is actually a lot of, it's landlord-tenant law, but it's more possessory interest law, and it goes towards evictions and what the right is to a tenant if there is an eviction. And if you read 5321D, the best interpretation you can make of that is the one I gave you earlier. It does deal with both written and oral leases. But if you look at that statute and you try to apply it to this case, you're not going to find it very applicable. I would agree with the state there. That's another concern you have to have with defense counsel's tactics. If their entire tactic was to put Mr. White on the stand to admit to it and then rely on that statute to give them any kind of bufferance or any kind of support, you're going to find that that statute doesn't do much for us. I would argue that there is case law that says, look, if you're paying someone to be in this house for several months, you do get some kind of possessory rights to that. And one of those possessory rights is that you have the ability to give someone permission to come to your house. I would argue that till the cows come home. That's not what the statute says. That's not what was brought up by defense counsel. Everything that defense counsel was trying to do was clearly erroneous. And I'm not saying that if we go back and have another trial of Mr. White's actions at 2 in the morning coming through a window that a jury's not going to say, look, I don't care if you have permission or not. I don't think you did because you did it surreptitiously. But what I'm saying is he never had a chance in this trial with defense counsel that was relying on this statute, had never gotten judicial notice prior to putting Mr. White on the stand, had made the issue of lease and permission his entire support for the entire time and did it improperly. That's my concern. It's not the facts. It's whether or not his defense counsel prejudiced his defense with this tactic, and I argue that he did. And because of that, Your Honor, I'd ask that this be remanded for a new trial, and if nothing else, Your Honor, has to be remanded for an evidentiary hearing on restitution. I appreciate it.
Thank you, counsel. Thank you to both sides. The court will take the matter under advisement and will issue a written opinion, and you can look on the website too. Thank you.
Thank you, Your Honor.